So we're here for motions for new trial, is that correct?
That is what today was scheduled for, Your Honor. However, at this point in time, the parties have come to a resolution for the motions for new trial and the remaining direct review, and are submitting to the court a proposed resolution to resolve these 5 individuals' cases.
So how many do we have?
5 of the 6 whose direct review has not completed. The one who's remaining is somebody who you've already considered the motion for new trial for, so will require no further
Okay,
issue
so
from the court.
we will be finished today at the courthouse.
Yes.
Okay.
So, as just a matter, we have Buckner-Webb, we have Copeland, we have Shawnee Robinson.
Michael Pitts and Sharon Davis-Williams.
Thank you.
And, Your Honor, may I put on the record what the agreement is, essentially?
Yes.
The proposed resolution as to each of these individuals is that the trial conviction would remain absolutely intact. The length of the sentence and the number of community service hours would remain the same as originally imposed by the court. So basically everything will stay the same with few exceptions. The prison portion of the sentence would be converted to probation. The defendant would waive whatever direct review rights remain, whether it is both a motion for new trial and a notice of appeal, or just a motion for new trial, or notice of appeal for one defendant, excuse me. And as I talked to all of the opposing counsel today, any habeas rights, so basically the right to contest the validity of this conviction, is something that they would be waiving. The defendant would acknowledge on the record that the evidence presented to the jury was sufficient to sustain the jury's verdict of conviction or convictions against them. The defendant would apologize to the children of the city of Atlanta, and that would have to be the defendant's own apology. It could not be an apology for being prosecuted. Because what is contemplated would be a probation-only sentence, OCGA 17-10-1, A1B i requires there to be a behavioral incentive date. And that would be set at 3 years from the beginning of their probation. And the last about the sentences, at sentencing, Your Honor, you encourage the defendants to begin their community service hours. So the state is asking the court to consider towards their community service hours anything that they can document beyond their own representation as far as community service hours that they have served in the past several years. And just to explain, this is not something that the state has spoken to the defense about for the purpose of avoiding the remaining motions for new trial or appeals. Every appeal of the convictions from this case have been sustained. Every motion for new trial has been denied. This was, in essence, us looking at the case. Multiple defendants at this posture had approached me and asked me if they could resolve the case in some way without the prison portion of their sentence. And one defendant, who I won't identify because I don't broadcast other people's personal business, had a particularly compelling issue that was a medical issue that I would prefer them to be with their family rather than in prison, considering this is a nonviolent act, despite its severity. And so I sought permission and fashioned a resolution that I advanced to all the defendants, and these 5 have decided to take advantage of that. And so that is what we are here for today. There were motions for new trial scheduled today that the court was prepared to hear, but this is resolving those matters.
So this was an agreement that the VAs have negotiated with those defendants?
Yes. I spoke to each of the defense attorneys individually, and then I sent an email en masse making sure it was very, very clear what the resolution was, and it is my understanding that each of the 5 individuals who are here before the court today agrees with that resolution. And I wanted to go through it and have the person and their attorney appear before the court and make sure those things are issued if the court is amenable to that resolution.
Well, I'm amenable, but I think it should have happened 10 years ago.
I understand, Your Honor.
10 years. And all sorts of things happened during that time, but it should have been taken care of 10 years ago. But here we are. I'm grateful. It's going to be over. I'm absolutely grateful that it's going to be over. And I just want to express my gratitude for the service of these jurors that served on this case. 9 months. And anybody that denigrates a jury is not sound, if you ask me. And they were diligent, they worked, they got along, they never were late. It was really amazing. So I want the last part of this record is to be praising those jurors.
Absolutely, Your Honor. And one of the animating parts of this resolution was that there would be nothing, this isn't a plea. Their verdict stands. Their verdict will remain. And this resolution will honor that verdict. Absolutely.
Okay. So I'm going to make you the master of ceremonies.
Yes, Your Honor. I will just go alphabetically. First, I will call Diane Buckner-Webb and Brandon Carter forward. It does not matter to me. You might want to be closer to the microphone either way.
Brandon, tell me your last name again.
C-L-A-R-K. Your Honor, Brandon Clark, Fulton County.
And what circuit are you from?
The Atlantic Judicial Circuit. Kind of space between Savannah and...
No, I used to spend a lot of time down there, and beautiful. What city do you live in down there?
It's in Liberty County, Fleming, Georgia.
Okay.
It's right outside Hinesville.
Well, a while there, I had a place by the wildlife refuge in there, in McIntosh. But anyway, welcome to the big city. I guess it's as hot down there as it is up here.
Absolutely.
Okay. All right.
Before you started, I did also want to thank the district attorney's office in your honor for this resolution. As you mentioned, it is kind of like the verses of the day is now lost in a long time. And we consider this offer, you know, stepping something to be a great act of charity and really at this point to allow this resolution to express my gratitude.
All right.
Is it Ms. Buckner-Webb or not?
Miss Buckner-Webb.
Miss Buckner-Webb.
Yeah.
Would you please raise your right hand? Do you swear affirm that the testimony and statement you're about to give the court will be the truth?
Yes.
Thank you very much. Please state your name for the record.
Diane Buckner-Webb.
Ms. Buckner-Webb, the resolution that I mentioned previously, is that something you were agreeing to?
Yes.
And I want to go over what you were convicted of and what the sentences already were, because that will determine what the sentences is moving forward, correct?
Correct.
Okay. On count 1, my notes are that you were found guilty of the RICO conspiracy, and that the sentence was a sentence of 5 years with 1 to serve, 1,000 hours of community service, and a $1,000 fine. Is that correct to your memory?
That's correct.
Okay. And on counts 18 and 19, excuse me, you were convicted of false statements and writings and sentenced to a concurrent suspended sentence of 5 years. Is that correct?
That's correct.
Okay. And so you understand that this resolution will reduce that, if accepted by the court, will reduce that to 5 years probation, but everything else will be the same. Okay. With the behavioral incentive date. Okay. On the record, I would like to ask you, do you waive whatever direct review rights or habeas rights and habeas rights that you currently have?
Yes.
So you understand that you will only be able to remove that information. Do you acknowledge that the evidence presented to the jury was sufficient to sustain the jury's verdict and conviction as to your offense? Do you you have an apology to read into the record?
Yes.
Please read it.
To the children of Atlanta Public Schools, I'd like to start by saying I am deeply apologetic for the children of Atlanta Public Schools for my actions as a teacher administrating the CRCT. I had a responsibility to do a public and fell short of the task. Due to the evidence at trial being sufficient to my conviction, I took precious time to analyze my part in what took place. I reflected on the things I could have done differently and discovered ways to regain my integrity in society. Despite my current illness, I continue to work hard as a productive member of society with a smile. Again, I apologize to those children I hurt directly or indirectly with my actions during the testing. As I truly loved my career as an educator, it meant the world to me to impart knowledge upon every student that entered my classroom, and it sincerely hurts me that it had to end this way. Yes, I take responsibility, and I am appreciative of the wonderful years I have had. Diane Buckner-Webb, Cecilia.
And that concludes my call to you,
So this is just a matter of paperwork now for
Yes, and I have collected from each of the individuals, including Ms. Buckner-Webb, their phone number, email, and home address, which I have been informed of what's necessary for probation to contact them in the next 24 hours.
all right, any service that they can document that they've done.
Sentencing sheet should be sufficient. Is now 5 years with the same number of community service and the same number of fine. Yes. And that will be the same for each of the individuals. It will just change based on what their original sentence was. Thank you. Next, Sharon Davis Williams and Attorney Andrew White. Dr. Sharon Davis Williams, will you raise your right hand? Do you swear or affirm that the testimony and statements that you're about to give the court will be the truth?
Yes.
Thank you very much. Please state your name for the record.
Sharon Davis Williams.
I'm going to review with you your convictions and sentence to ensure that they are accurate. You were found guilty of count 1, the RICO conspiracy, correct? And you were sentenced to a term of 10 years, with the first 3 years to serve in custody, the remainder on probation, a $10,000 fine, and 2,000 hours of community service. Is that correct? And you were found not guilty of false statements in running counts 5 and 6. I will also like to ask you, you currently have a notice of appeal pending from this conviction, correct? And you understand that what we're about to talk about will be a waiver of that notice of appeal. Okay. Do you understand that the sentence that we've just gone over will remain the same, except the prison portion will be removed? Okay. Do you waive whatever direct review and habeas rights remain to you at this point in time? Is she speaking loud enough? Okay. I just wanted to make sure. Okay. And you understand that through this resolution, you are giving up your right to contest your conviction. Okay. Do you acknowledge on this record that the evidence presented to the jury at your trial was sufficient to sustain the jury's verdicts of convictions for those offenses? Okay. Do you have an apology for the children of the city of Atlanta? Please read it now.
Thank you for this opportunity to meet today to discuss this matter. Please allow me to state up front that I apologize and I take full responsibility for what occurred in schools under my supervision. Although I was not in the classroom where the cheating occurred, it goes without saying that I was responsible for ensuring the integrity of schools under my supervision, which included work processes and measures that were in place to prevent the occurrence of illicit behavior of staff under my supervision. My confidence in the accountability procedures that I followed was misplaced. I deeply regret the impact of this situation on the schools, the broader community, including staff, parents, and most importantly, the children. I chose urban education despite, or more candidly, because of the difficulties believing that all children deserve high-quality education regardless of their individual circumstances. My entire career has been devoted or dedicated to children in low-income communities. My greatest remorse is that I failed to protect the very children I dedicated my life to serving. And I apologize, and I take full responsibility. I understand the need to make amends, and I will continue to work tirelessly in my community.
Thank you. You were assistant superintendent? Or?
No, sir. I was an executive director. I was like a tier 3. I had a deputy superintendent over me and then a superintendent. And I worked in a section with a section of schools.
The pressure was unbearable in the Atlanta public school system at that time, the test scores. Would you agree with that?
Yes, sir. The accountability for performance was there. Yes.
And you'd be let go, not renewed, or you didn't reach certain quotas?
Well, in my area, there was not anyone let go for that reason in my particular.
Well, anyway, good luck. And you performed some community service already?
Yes, sir, I have.
Okay, well, that'll be counted. Mr. Fleischman, have you been on TV lately? Or?
Not lately, Your Honor, but
Okay.
I will say for Ms. Williams that she has done more than 2,000 hours of community service.
Okay.
I think she's taken this extremely seriously. And although she was acquitted of a lying, she takes part for her responsibility for the system, the way that the system works.
Thank you.
It's 10 years probation.
May we be excused, Your Honor?
Yes.
Next, Your Honor, is Michael Pitts and Attorney Mac Taylor.
Good morning. So, what circuit are you?
I'm public defender in the Columbia Judicial Circuit.
So that's
It's next to Augusta.
next to Augusta. All right.
Soon to be second. Please raise your right hand. Do you swear or affirm that the testimony and statements you're about to give the court in the matter now before it will be the truth? Please state your name for the record.
Michael Pitts.
And Mr. Pitts, I'm going to go over the sentence that was originally imposed, or the amended sentence that was originally imposed. For count 1, you were found guilty of the conspiracy, the RICO conspiracy, and sentenced to a term of 10 years, with the first 3 to serve in custody, a $10,000 fine, and 2,000 hours of community service. Is that correct?
Correct.
You were also found guilty of count 4, influencing witnesses, with a 3-year to serve concurrent sentence. Is that correct?
Correct.
You understand that the resolution that we have discussed here today, everything would be the same about your sentence except the prison portion. On this record, do you waive whatever direct review and habeas rights remain to you to contest this conviction? Do you acknowledge on this record that the evidence presented to the jury in your trial was sufficient to sustain the jury's verdicts of conviction against you?
Yes.
Do you have an apology for the children of the city of Atlanta?
Yes.
Please read it now.
Good morning.
Good morning. Good afternoon.
Yeah. Thank you for agreeing to meet with us today, Judge Baxter.
I take full responsibility for the circumstances that brings us here today. During the court proceedings, it was stated that I never told anyone to cheat. However, I should have known cheating was occurring. Although I wasn't aware and was occurring in some of my schools and classrooms, I would like to note that I supervised 3 schools and it wasn't occurring, but I was not diligent enough, nor did I have the correct safeguards to protect my students from harm. I sincerely apologize to not only the students under my supervision, but all the students at Atlanta Public Schools. I worked in the Memphis City School District for 20 years, where I was deemed a distinguished teacher and a distinguished principal. My entire career was dedicated to inner city schools. I believe all children can learn at high levels, no matter what their zip code. I accepted the role as executive director in Atlanta, believing that I could utilize my expertise to help more students in that capacity. I had no accusations of unfairness and intimidation. I worked here for 12 years, and I always said to myself, only fools fool themselves, which this statement goes directly to the heart of cheating. If you begin to skew your baseline, you will never get a true picture of student or school's progress. In some ways, I was not true to my own mantra. I failed my students in Atlanta by foolishly not doing a close inspection, understanding how some confuse.
Just a little bit.
I'm sorry. Some confuse accountability with pressure. I believe that the lack of accountability is the root cause of failure in our school system. However, it has never been my style to scare people into doing their job. I've always sought to hold myself accountable to all people I have served. I would not shy away from this accountable moment either. Cheating occurred under my watch that did harm to my children, and for that I am deeply apologetic. I pray that they have recovered fully from the disservice and any disadvantages they endured during my tenure. I have recently written a book, which I feel like I served from this experience and the lessons I learned from it. I have distributed many copies throughout school communities freely. My hope is that the future educators can learn from both our successes and our mistakes to make for a brighter future for our youth.
Let me ask you a serious question. Why did this happen? How did this happen? Why did this happen?
In my opinion, again, I said it in my statement. Accountability is important. If you notice, a lot of schools are still struggling based on the fact that some people think children cannot learn, and therefore they're underserved. When you come into a district, particularly from outside, people may think you're being overbearing, but you're really trying to improve student achievement. I believe, and I came from Memphis, where my schools were rated #1 in the state, and it was totally the poorest schools in the district, and that should be verified. I know children can learn. We have to teach them. We can't run from accountability, but we cannot be oppressive. Never was, and I never will. Thank you.
Wait a minute, I still didn't answer the question. How did this happen? How did this begin? How did it happen? How did these multiple educators just start cheating? I mean, what was the impetus for that?
I'm not sure. I think it's an impulse for people to go out and cheat. I wouldn't cheat. Kids never have.
It was Beverly Hall, wasn't it?
Beverly Hall was superintendent of school.
And she put unbelievable pressure on everybody in the system to perform to really unachievable goals. And if you didn't do it, you got fired. Are you aware of that?
I've never fired anybody 12 years for testing.
Okay.
Judge, that was my take on it, reading through this transcript, and I think he wants to be somewhat respectful of his former boss. I think that's what he did. Absolutely.
Your Honor, we obviously wildly disagree about the fact. We would agree to honor the jury's verdict and acknowledge that the jury's verdict, which found intentional cheating and conspiracy to do so, is valid. And so I don't want it to sound like the state agrees with that particular apology or the last one the court heard. But that is one of the reasons that this resolution is
They were a little squishy.
correct.
Like it's, it's not my fault, any of this.
Some people's apologies are more genuine than others.
Well, anyway, I'm ready for this to be over. And so I'm not going to quit it. So, is anything else?
Not this defendant, Your Honor.
Okay, thank you very
Thank you.
much. Okay. Thank you. Yes, thanks.
And last is Shawnee Robinson and Bethany Page.
Who is that just left the courtroom? Lady? Was that somebody with y'all?
I think it was. I think it was Mr. Pitts' daughter.
Yeah, well, maybe you need to talk to her, Mr. Pitts.
Oh.
Please raise your right hand. Do you swear or affirm that the testimony and statements you're about to give before in the matter now before the truth?
Yes.
Please state your name for the record.
Shawnee Robinson.
Ms. Robinson, I'm going to go over your sentence from the first trial, and I want to ask if the convictions and sentence are correct. You were found guilty of count 1, the conspiracy to commit RICO, and received a 5-year sentence with the first year to serve in custody, 1,000 hours of community service, and a $1,000 fine. Is that correct?
Yes.
You were also found guilty of count 18, false statements in writing, and received the same sentence on that count. Is that correct?
Yes.
You understand that the resolution that we are putting before the court here today is one that this sentence will remain the same, but except for the prison portion will be probation.
Yes.
Okay. Do you, on this record, waive whatever direct review and habeas rights you have left to contest the conviction?
Yes.
Do you acknowledge on this record that the evidence presented to the jury was sufficient to sustain the jury's verdicts against you?
Yes.
Do you have an apology for the children of the city of Atlanta?
Yes.
Please read it.
Good afternoon. To the children of Atlanta, I am writing this letter as my personal apology to the students in Atlanta Public Schools and to take full responsibility for my actions in this case. As a former teacher, it was my duty to ensure a high ethical standard. I am deeply remorseful for any testing irregularities that occurred on my students' 2009 CRCT test. I apologize for any harm my involvement in this case may have caused you. I realize that this situation has damaged public trust placed in educators. Since my conviction, I have been dedicated to rebuilding that trust and will continue to do so moving forward. Upon leaving the field of education, I served as a counselor for underserved children in the Department of Juvenile Justice and the Department of Family and Children's Services. I volunteered for a nonprofit in which I taught high school students career exploration and job readiness skills. As a member of a local community organization, I also work with high school girls transitioning into adulthood, teaching them life skills. I hope that you will consider my apology and the efforts that I have put into my community. Thank you.
Where are you?
Southwestern Judicial Circuit, Your Honor, in Americas.
We just got lawyers from all over the state here.
Yes.
That had to be this had to be farmed out to you, right? How many pages is the transcript? 20,000 something?
I'm not sure. It's very long.
Anyway, thank you for your help.
I would like to do a couple of clarifications, please. This is a first offender sentence. The sentences for the two different charges are concurrent, yes?
Yes.
And it's only one $1,000 fine and $1,000 hours community service. Is that right?
That is my understanding of it.
And it seems like you've been doing a lot of work, and you're going to be given credit for that. I think that was a very good decision to make. So, are we done?
That is it for today, Your Honor. Absolutely. And I believe that is it for you permanently. You're the only person remaining who has a notice of appeal. You've already ruled on a motion for your trial.
So I can just go out in the pasture and Die.
If that is your choice, I don't ask that you do that. We like having you around, Judge.
Okay. All right. Good luck.
Thank you.
You did say the last thing you wanted on the record was an appreciation of the jury's service and their work on this case, and so I wanted to mention that at this conclusion, because that was an extraordinary effort, and based on everything that you said on the record, as well as subsequently, they were remarkably diligent, attentive, and participatory as far as making sure that they came to a correct conclusion.
They were incredible. So I guess that's it. I want to thank y'all for negotiating this. There needs to be an end, and I'm comfortable with it. So
Thank you, Judge.
anyway, we're adjourned. So I'm gonna need to fill out some papers. Okay, well, I'm gonna be up in my office, up on the 8th floor.
Yes, sir.
So just give me a call.
Absolutely. I got it from,
Okay.